Dear student, in this short video, we shall examine and solve certain illustrative questions on legal aptitude based on criminal law, which have actually appeared in various law entrance examinations. The first question which we take up is this, which is an actual question from CLAT 2014. We find here that there will be one principle, then certain facts, and in the next slide there are certain options out of which the student has to choose one. The principle in this question is this: whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. In this principle, we find that the offense of theft has been defined, and this offense has certain ingredients. We shall examine them. First of all, let us note that theft can be caused only in respect of a movable property, which means not in respect of an immovable property. Secondly, we should note that the intention should be to take that property dishonestly. So therefore, we need to know what is the meaning of dishonestly, and if that property with that intention is moved, then the offense of theft is committed. With this principle in mind, the student has to examine the facts which are subsequently given. The facts in this case are: Z, going on a journey, entrusts his plate to the possession of A, the keeper of a warehouse, till Z shall return. Then A carries the plate to a goldsmith and sells it. On these facts, the student is required to tell whether the offense of theft as defined in the principle has been committed in this case or not, and the options which are given are these: A has committed theft, A has not committed theft, A lawfully sold the plate to the goldsmith, none of the above is true. Now, before answering this question, it is my endeavor to familiarize the student with the actual principle which is there in the Indian Penal Code and the illustrations which are given thereafter. These illustrations will familiarize the student with normal facts which may appear in law entrance examinations. Now, moving on to the next slide, we find that the definition of the offense of theft, which is given in the IPC in section 378, is this. Now, the student will find that this definition is exactly the same as is given in the principle in question number 1 above. And once again, the student should note that the word which is very important is dishonestly. The property should be movable property, and intention should be to take it dishonestly, and then there should be moving of that property. And also it should be noted that the intention should be to take the property out of possession of any person without that person's consent. These are the ingredients. Now, an important word, dishonestly, we have to examine this, and we find that this has been defined in the IPC. This is the definition given there. It says, whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to do that thing dishonestly. Thereafter, IPC has certain illustrations which will exemplify the definition which is given in the section. The first illustration available in the Indian Penal Code is this. A cuts down a tree on Z's ground with intention of dishonestly taking the tree out of Z's possession without Z's consent. And then thereafter, we are required to give the answer whether this action of cutting the tree amounts to theft or not. Now, we note here that tree is an immovable property and this cannot be a subject of theft. However, as soon as the tree is cut, it becomes a movable property and therefore it becomes a subject of theft. even though the property has not been moved, even though the tree has not been moved out of Z's ground, still the mere act of cutting the tree amounts to theft as per the Indian Penal Code, because the code says that as soon as A has severed the tree, in order to such taking A, he has committed theft. Therefore, if the question involves these types of facts, then our answer should be that even though the tree has not been actually taken out of the field, the mere act of cutting that tree amounts to theft. In the second illustration, we see these facts. A puts a bait for dogs in his pocket and thus induces Z's dog to follow it. Now, in this case, A has done nothing to the dog. He has not interfered at all in the dog's functioning. However, still the IPC says that it amounts to an offense of theft. Let us see the answer which is given in the IPC. It is this: if A's intention be dishonestly to take the dog out of Z's possession without Z's consent, then A has committed theft as soon as Z's dog has begun to follow. The student will find here that what is important is the intention. If the intention is to dishonestly take the dog, then even if nothing has been done to the dog, the mere moving of the dog amounts to theft. Moving on to the next illustration, we find the facts as under. A meets a bullock carrying a box of treasure. He then drives the bullock in a certain direction in order that he may dishonestly take treasure. Here also we find that A has not even touched the treasure, he has simply moved the bullock. But even then, the answer which is given in the IPC is that as soon as the bullock begins to move, A has committed theft of treasure. So the student will note that it is not necessary that the treasure itself has to be moved. In this case, the treasure was on the bullock and the bullock has been moved by A, and this moving of the bullock amounts to theft of the treasure. Next illustration is this: A, being Z's servant, entrusted by Z with care of Z's plate, dishonestly runs away with the plate without Z's consent. Now, in this case, whether the action of A running away with the plate amounts to theft or not, the answer will depend whether A took the plate out of the possession of Z without Z's consent. Now, in this case, as the facts show, the plate was actually given by Z himself to A, and therefore it cannot be said that A took possession of the plate from Z without Z's consent. Even then, the answer of this on these particular facts as given in the IPC is this: the answer is A has committed theft. So, how has it come about? We will go back to the earlier slide which gives us the facts. We find that even though Z himself had given the plate to A, plate here is some valuable item, it may be anything else also. So, in this case, Z himself had given the valuable item to A, and therefore A did not take the possession out of Z without his consent. However, in case of master and servant, the legal position is that anything which is in servant's possession is legally in possession of the master. So, therefore, even when the plate had been handed over to A by Z, the master, legally the possession is still with the master, which means Z, and therefore if A has thereafter run away with the plate, we say that it has been taken out of Z's possession without Z's consent, and therefore it amounts to theft. So that is why this answer is like this. Moving on to the next illustration. This is a similar illustration Z is going on a journey, entrusts his plate to A, keeper of a warehouse, till Z shall return. But thereafter, A carries the plate to a goldsmith and sells it. In this case also we find that Z himself had given possession of the plate to A. Now, even though the facts of this illustration are similar to the earlier illustration, the answer will be different. And the answer as given in the Indian Penal Code is this. Here the plate was not in Z's possession. It could not therefore be taken out of Z's possession. Going back to the facts, we find that Z himself had given the plate to A. In this case, A is not a servant of Z as in the earlier illustration. A in fact is a stranger to Z, and therefore once Z gave the possession of the plate to A with his own consent, it can never amount to the offense of theft, and therefore the answer will be that A has not committed theft, though he may have committed criminal breach of trust. That is a separate offense which is not part of this question. Moving on to the next illustration. A finds a ring belonging to Z on a table in the house which Z occupies. In this case, the ring is not in Z's pocket, not in his physical possession, not on his finger. The ring is actually lying on a table inside the house of Z. The legal position is that anything lying in the house of a person is in possession of that person. Therefore, even though the ring is not in actual physical possession of Z, the mere fact that it is lying on a table in his house amounts to saying that the ring is in Z's possession. So, if A takes that ring from the table, it amounts to A taking the ring out of Z's possession and without Z's consent, and therefore, on these facts, the answer will be this. Here, the ring is in Z's possession, and if A dishonestly removes it, A commits theft. Moving on to the next illustration. The facts are: A finds a ring lying on high road, not in possession of any person. Now, if A picks up such a ring, will it amount to an offense of theft? We find that A finds the ring lying on the high road, not in possession of any person. Since the ring is not in anybody's possession, there is no question of A taking the possession of the ring out of somebody else's possession, and therefore, in this case, it will not amount to theft. And the answer given in the Indian Penal Code is also the same, that A, by taking it, commits no theft, though he may commit criminal misappropriation of property, which is a separate offense not involved in this question. Moving on to the next illustration. A sees a ring belonging to Z on a table in Z's house. Now, in this case, A does not take the ring away, but he hides the ring in a place highly improbable to be ever found by Z, with the intention of taking it from the hiding place later. So, the ring is still in Z's house. However, A has hidden it in such a place that Z can never find it. Therefore, in this case, we would say that the ring is now no longer in possession of Z. It has been taken out of the possession of Z, despite the fact that it is still lying hidden somewhere in Z's house. In such a case, it will amount to the offense of theft. But at what point of time? It amounts to the theft at the point of time when it is first moved. And the answer as given in the IPC is also the same. It says that A, on first moving the ring, commits theft. In this case, A has not actually taken the ring out of Z's house. Still, it amounts to theft because he has moved the property and he has taken the property out of Z's possession without Z's consent. We now have two more illustrations. The next one is this. A, being on friendly terms with Z, goes into Z's library in Z's absence, takes away a book without Z's express consent for the purpose merely of reading it with the intention of returning it. Here we find that A has taken the book out of Z's possession, that is from his library, without his express consent. But he has not taken it dishonestly because he has the intention of returning it. And secondly, there is no express consent of Z, but maybe there is an implied consent because A and Z are friends. So on these facts, the answer which is given in the IPC is this. Here, A may have conceived that he had Z's implied consent to use Z's book, and if this was A's impression, then obviously A has not committed any theft because then there is a consent of the person who was in possession. The last illustration is this. A in good faith, believing property belonging to Z to be A's own property, takes that property out of B's possession. Now A has taken this property considering it or believing it to be his own property. Therefore, there is no dishonesty involved in it because he thinks the property to be his own, and therefore the answer will be that it does not amount to theft. The IPC also gives the same answer. The answer as given there is this. Here, as A does not take dishonestly, he does not commit theft. So, students, these are certain illustrations which are given in the Indian Penal Code itself, and these illustrations guide us as to how to answer questions which are based on this principle, which I find is actually appearing in various law entrance examinations in different years. With this understanding of the law and the illustrations which are given thereafter, now let us go back to the question which we started with and let us try to answer this question. We note that the principle is exactly the same as is given in the Indian Penal Code in section 378. This principle defines the offense of theft. The ingredients are there should be movable property, intention to take dishonestly must be there, and out of possession of somebody and without that person's consent. So this is how we should actually read the principle. The various components of the principle must be clearly understood, and thereafter let us go to the facts. The facts are that Z, going on a journey, entrusts his plate to the possession of A, the keeper of a warehouse, till Z shall return. Then A carries the plate to a goldsmith and sells it. You will find that these facts are exactly the same as are given in illustration E to section 378 of IPC. We have already seen these facts earlier in this video, and we have also seen that the answer which is given in the IPC on these facts is that A has not committed the offense of theft. Why? Because the plate was actually given by Z himself to A. Therefore, A has not taken the possession of the plate, that is the valuable item, without Z's consent, because it was given by Z himself. And since this is the situation and the possession is not taken without that person's consent, it does not amount to theft. So now we are well equipped to answer this question. These are the four options, and clearly the correct option is B, that is A has not committed theft. The simple reason, as I stated earlier, is that the plate was handed over by Z to A, and therefore it is not correct to say that A took the possession of the plate without Z's consent, so it is not theft, and therefore the correct answer is B.